I am Lily Schroep, the Marketing and Communications Manager here at CPR. If you are interested in attending more CPR programs and staying current with the most relevant topics in ADR and dispute prevention, you may want to subscribe to one or more of our CPR communications, including our email newsletter, The Date Book, our blog, CPR Speaks, and our monthly journal, Alternatives. You can subscribe on our website, cpradr.org, and of course, you can unsubscribe at any time. Our next panel is Ethics in the Evolving World of Remote, Hybrid, and In-Person ADR. The moderator is Steve Bierman. Steve is a mediator, arbitrator, and the founder of Bierman ADR LLC. He serves as a neutral on several ADR rosters and is a fellow of the Chartered Institute of Arbitrators. Previously, Steve was a litigation partner at Sidley Austin LLP, where he led or co-led the New York litigation practice for 25 years and was a leader of the global complex commercial litigation practice. Steve is co-chair of CPR's mediation committee. Welcome, Steve.
Well, thank you, Lily, for that kind introduction, and welcome to everybody. We have assembled a fantastic panel of experts in the subject we're going to address, and I'm excited to introduce each of them briefly. Susan Guthrie is recognized as one of the top family law attorneys and mediators in the United States. She also is an internationally prominent expert on online mediation. Susan founded Learn to Mediate Online in 2018, and to date has trained, wait for it, more than 20,000 dispute resolution professionals and others. In 2020, Susan teamed with the legendary Forrest Woody Mostyn to create the Mostyn Guthrie Academy, offering trainings and programming for attorneys and ADR neutrals. She is an in-demand speaker. Next, we have Jill Pilgrim. Jill is the managing attorney of Pilgrim Associates Arbitration, Law, and Mediation LLC based in New York. Jill has extensive experience with complex commercial matters, having begun her career with a major New York law firm, then as the general counsel of several major sports organizations, notably US Track and Field and the LPGA, and as a prominent mediator, arbitrator, and expert witness. Jill teaches sports arbitration at Columbia Law and is a member of CPR's Distinguished Panel of Neutrals. Paul Genender is a partner at Weil, Gotshal and Manges, where he is the leader of Weil's litigation practice in Texas. Paul is a seasoned litigator and trial lawyer with a strong courtroom record, representing clients in connection with a wide range of commercial disputes. His expertise includes litigation involving restructuring, antitrust, deceptive trade practices, non-compete and restrictive covenants, misappropriation and theft of trade secrets, and securities fraud, among others.
You're on mute. You're on mute. You're on mute, Steve.
Steve, you're on mute.
You're on mute, Steve.
Well, I suppose that raises the question of when did I go on mute?
After my introduction.
Okay. And it raises the interesting question, if you don't touch the mute icon, how do you go on mute? But ergo, the subject matter of our panel. I was about to introduce, or was practicing introducing Ellen Waldman, whom you've met a couple of times during the course of the meeting, but I want to say a few things about Ellen. Ellen recently joined the CPR Institute as the Vice President of Advocacy and Education Outreach. She's been a leader in the fields of mediation and medical ethics for more than 2 decades, has taught at several law schools. She trains and mediates in a broad range of cases and has been deeply involved in issues relating to mediator qualification and ethics. Ellen has published extensively, and she crafted the first book-length treatment of ethics issues in mediation called Ethics, cases, and commentaries. You know, a lot of people refer to, and too loosely to, she or he wrote the book. Ellen actually wrote the book. We've also included a wealth of resource materials in the CPR course book, which we commend to you. We'll mention a few of them along the way, but when you have time, please take a look at them. And I will be giving a single CLE code about 2/3 of the way through the program. Stay tuned for it because it is for the highly coveted ethics CLE credit. So let's set the table. The necessity to be remote these past 2 years has obviously and profoundly changed how we all work and interact, including how we address disputes through ADR. The new normal is still emerging. Some people expect that in-person proceedings will again arise and maybe predominate, and some expect that remote or hybrid proceedings will be the way to go. And the panel moderated by Colin Rule yesterday gave us a glimpse of an eventual dispute resolution future driven by algorithms and AI in partnership with humans. Well, at least the humans hope they will be partners, at least for now. And our panel this morning underscored that direction. I think it's fair to say that many would say there will be no single paradigm, but instead a bespoke approach, depending on the dispute, the party's interest and relationship, costs and convenience, and the like. But one thing for sure, or maybe two, is that remote ADR proceedings are here to stay, and technology, as we've been hearing throughout this 3-day program, will continue to evolve. Our panel will first, we can go to the agenda slide. Our panel will first examine the ethical obligations of arbitrators, mediators, and advocates relating to technology-driven ADR. I want to pause just for a second. We are dealing with the world as it is now, for the most and greatest part, for mediators, arbitrators, and counsel dealing with ADR in these processes. We are not addressing, except by reference to stay tuned, we're not really addressing the future world of AI and algorithms and ODR more generally. I will tell you, though, that we're already planning next year's program, and I may be back with my avatar. And I have to tell you, my avatar has a beautiful head of hair. So after we examine the basic ethical obligations, we'll explore some of the challenges and possible solutions in the new normal that we are experiencing, and a bit about the evolving, even newer normal. And finally, the panel will offer some takeaways for how ADR participants can meet this ongoing challenge. So let's begin at the beginning. Our professor, our person who wrote the book, and new joiner to CPR, Ellen, please walk us through the sources of multiple ethical obligations and focus us on the ethical duties that are most relevant to conducting mediations or arbitrations using technology. And you all will begin to see just how lucky CPR is that Ellen has joined the team.
Thank you, Steve. I appreciate that introduction. So my role on this panel is to lay out the ethical landscape, but I wanted to start by noting the somewhat murky relationship between law and ethics. Some say that if law sets out a minimal floor of behavior, then ethics points upward toward an aspirational ceiling. But Justice Earl Warren seems to suggest that the relationship is much closer, that our legal rules are animated by or nestled in a set of norms that give those rules life and sustenance. Although some ethics codes in the ADR arena might be purely hortatory without any enforcement bite, others have become the basis for legal requirements, the violation of which can get a neutral kicked out of a provider organization, delisted from court rosters, censured, and in rare cases sued for professional malpractice. Our focus today is on the rules that have been generated, adopted, and promulgated by the most authoritative organizations and trade groups, including the American Bar Association, the Association for Conflict Resolution, CPR, and the like. These are the rules you're most familiar with. And you will note, for the most part, they don't speak directly or only obliquely to technology and its uses. What we are in the main going to be doing today is translate the old familiar concepts embodied in these old familiar codes to our new technologically complex settings, old wine into new bottles. But spoiler alert, there are new codes being promulgated by think tanks, trade groups, academic institutions, concerned citizens, not yet widely adopted, but in circulation, a sampling of which are included in your materials. And these codes will likely become the templates for future ethics guidance. Okay, but for today, what guidance do our tried and true authoritative ethics codes have to offer us as we move to remote practices? So we're going to be looking at essentially the model rules of professional conduct for lawyers adopted by the ABA Board of Delegates in 1983. This serves as a model for the binding rules in every state, including most recently California. We're looking at the model standards for mediators adopted by the ABA, AAA, the Association for Conflict Resolution. We're going to be looking at the ABA AAA Code of Ethics for arbitrators in commercial disputes. And there are other codes in your materials, including CPR's own rule 4.5.2, which governs the conduct of a lawyer serving in a neutral posture, binding on all CPR neutrals, as well as being just an excellent summary of how attorneys' ethical obligations change when they shift from an advocacy to a neutral role. All right, so first, looking at our guidance for lawyers, we turn to Model Rule 1.1 devoted to competence. And as you can see, the rule provides that a lawyer must be competent in representing their client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation necessary for the representation. At one time, legal knowledge and skill could be limited to substantive knowledge of the law and process skill in the arts of drafting, analysis, oral communication. But today, knowledge and skill has to encompass a mastery of the technological tools that are going to be put to use in the course of the legal proceeding, as well as in any mediation arbitration. You see that comment 8 specifically alludes to this, stating explicitly it's not enough to stay current on case law, regulatory law, statutory law. You have to keep abreast of changes in practice, including the benefits and risks associated with relevant technology. The model rules also direct attorneys to ensure that client confidences are kept confidential. The rules state that the attorneys should not either intentionally reveal information related to client representation, but also should avoid inadvertent disclosures or a situation where third parties are permitted to access the information. So again, no explicit mention is made of the particular obligations technology imposes, but obviously the duty to safeguard sensitive client information becomes ever more pressing as mediations and arbitrations are conducted remotely and the risks of cybersecurity lapses and data breaches become ever more real and acute, as we learned in yesterday's rather terrifying cybersecurity panel. Moving to the obligations of mediators, the model standards of conduct for mediators also impose duties of competence on third-party neutrals. And this duty is encompassed in Standard 4, as you can see. Like lawyers, mediators are required to only accept cases that they're competent to preside over. And interestingly, these standards link competence to the reasonable expectations of the parties, which frankly, I have always found to be a little bizarre if you think about it, as in many instances, parties to a mediation have little idea exactly what to expect, and oftentimes their expectations are misguided. But at any event, another provision in this code says that regardless of what the parties expect, the mediator if she begins to suspect that her competence or suitability for a given dispute is questionable, then the mediator has a duty to take action, which may include withdrawing or obtaining assistance. Again, no specific mention of technology, but obviously the duty of competence extends to mastery of the tools being used to convene and manage the session. Standard 5 deals with confidentiality, right? And notes that the parties might have different expectations regarding confidentiality and that the mediator needs to address those expectations. This has traditionally been interpreted to mean that a mediator should explain and confirm the party's understanding of relevant evidentiary rules, privileges, and reporting requirements. But this mandate could also be viewed as applying to expectations about what, if anything, is being recorded, how remote communications are kept private, and how secure the mediator's data storage is. Lastly, also on point is Standard 6, the omnibus quality of the process standard, which really emphasizes the traditional components of procedural fairness. The mediator has to be thinking about whether all the appropriate stakeholders are present, whether they're able to participate adequately. The process has to be one where all the parties feel they have a voice and are being treated with dignity and respect. And you can just imagine all the myriad ways in which technology mishandled can interfere with that goal. Next, we turn to guidance for arbitrators. And the salient provisions to focus on here are Canon 1. In the context of securing the integrity of the process, it sets out a duty of competence, right? And the duty to make reasonable efforts to avoid disruption of the process. Canon 4, which discusses the need to structure the process with an eye to procedural fairness, and Canon 6, which requires the arbitrator keep confidential all matters relating to the arbitration proceedings and decisions. Now, we would be remiss, given we are at CPR's annual conference, if we didn't spotlight CPR's own rule, which was designed to amplify Rule 2.4 of the model rules, which sets out the ethical obligations of lawyers functioning as third-party neutrals. And you'll note that this code contains by now familiar language relating to competence, confidentiality, and procedural fairness. A particularly excellent aspect of this code is that it calls attention to the particular challenges facing unrepresented parties. And of course, parties who lack access to counsel are also at risk of being disadvantaged by lack of access to and familiarity with technological resources. Lastly, and we promised we would at least make some mention of newer codes that specifically address the ethics of remote practice. The National Center for Online Dispute Resolution has drafted what it has termed a GPS for the field, setting out principles that it suggests should undergird not simply the actions of participants, but systems designers who are thinking through how exactly these new online processes should be put together. So not widely adopted yet, but a harbinger of things to come. So although obviously lawyers and neutrals' roles and ethical obligations differ, we see some broad common themes emerging for all of these participants in the process. And we're going to focus on the ethical duties in these three major categories. First, competence. Second, confidentiality. And third, maintaining a quality process, fairness and quality.
Well, thank you very much, Ellen. That was terrific. And I think that really does set the stage for the rest of our program. So what are some of the tech-related failures and challenges that we're talking about that intersect with these three key ethical duties: competence, confidentiality, maintaining a fair and quality process. We want to share some cautionary tales, so to speak, from the new normal. And we're going to start with a video that we found online that dramatizes some of what we're talking about. It's from a unique perspective, we thought, and you may find it a bit all too real. So let's run the video.
Hey, Paul. Thanks for being here on time. Paul? Hey, Paul, can you hear me?
I can't hear you.
I can hear you. Can you hear me?
Hey, guys.
Hey, Tyler.
Sorry I'm late. Having a hard time connecting.
1 second. Paul's having a sound issue.
I can't hear you. Try adjusting your output settings.
Can you hear me?
It's the gear icon.
Tyler, are you on hotel Wi-Fi?
Yeah, why?
Never mind, I got it. I just had to change a few settings.
Great, great. Maybe we can get started then. Oh, great.
I think your mic is speakers.
My mic?
Do you have headphones?
You want me to put them on?
No, I want you to smell them. No, I want you to put them on. Hey, Beth.
Hey everyone, sorry I'm late. I had to download a new version of the platform.
You should plan extra time for the updates. There's pretty much one every time.
Sounds like someone just joined.
Hey guys, it's John. I had to call in. I'm stuck in traffic. Have I missed anything yet?
No, it would have been nice for you to join the rest of us, but we'll see you when you get home. All right, while everyone is here, finally, Tyler, do you have that financial report?
Well, it's been the last few weeks updating our books, and I got some great news for you. Schedule from this point last year. We had a great Q1.
We lost Tyler, I think.
Am I frozen?
Hey, Trip, I think we lost Tyler.
Yeah, I know, we lost Tyler.
Hey guys, it sounded like Tyler was cutting out.
We know, John. All right, while we wait on Tyler, why don't we go over all of the reports from... Beth, are you with us?
Oh yeah.
Okay, everyone, I know some of you have to leave soon, but I just wanted to go over a couple of the queries before. Okay, excuse me. My wife's out of town this week. Daddy's, I'm so sorry. Okay, you just spilt grape juice on the carpet. Daddy is in a meeting. Tyler, can you go over the numbers one more time, please?
Sorry, guys, that's my iTunes.
Hey guys, hang on. I'm gonna join in. Hey, what platform?
That's in the invite.
Oh, never mind. I see it. It's right there in the invite.
Okay, now I can see everybody. Let's reschedule and let's just do a regular old conference call, okay? Paul, can you have David send out the 9-digit passcode? I heard you.
Yeah, he's been here the whole time.
All right, everybody. I'll see you later.
So I've seen that clip at least 10 times in preparing for this panel, and I have to tell you, it hits home and makes me laugh every time. In any event, let's now make it real for all of our attendees here today. We want to conduct 2 very quick polls to get your experience. Poll number 1, let's put that up. Poll number 1 asks you the question, have you experienced technical problems or disruptions in a remote ADR proceeding other than, Steve, you're still on mute? Simple response, yes or no. Please respond. And we'll see where we are in a moment.
Steve, I think you can move on to the second poll.
Okay, just give me a second here. So on poll number 1, interestingly, I would have thought it would be 100%. I want to meet the 18% who didn't have a problem with tech issues following the meeting. But in any event, that's great. Let's go on to poll number 2. Poll number 2 asks the question of each of you: who was responsible for the technical problems or disruptions you have experienced in remote ADR proceedings? In this case, check all that apply. And the choices are the ADR neutrals, counsel for a party or witness, an internet provider, an uninvited toddler, pet, or stranger. In any event, someone other than you. And our last option is, come on, admit it, even you. Please respond and we'll see what this looks like. So it looks like the principal culprit is our parties and witnesses. But interestingly, looking at the choices, there's something for everyone, and it is great to see our self-effacement in the last one, that at least 45% of us admit that we've caused some problems from time to time ourselves. So with this backdrop, let's look at some real-world issues through the lens of the 3 key ethical duties that Ellen identified in her presentation: competence, confidentiality, and quality and fairness of process. Susan, please start us off with the duty of competence, and maybe begin with, what does it mean to be technologically competent?
Thanks, Steve. And isn't that a great question to start with? When Steve asked me to start with that question, because I talk about competence and being competent online all the time, but it was an interesting way to come at it. How do we know that we are competent to be an online provider of our services? So I did what I think we all do when posing a question or having a question posed to us. I Googled. And I wanted to find out, basic understanding of what it means to be competent, and we can come at it from that direction. So competence is made up of these 3 things: knowledge, understanding, and then application. And I found a great example, an analogy of competence from the perspective of building a wall using these 3 key factors. So knowledge is, if you were considering having to build a wall, do you know what goes into that? Bricks, cement, whatever you're going to be making it about, that's the knowledge of what goes into our wall building. Then you need to have an understanding. Do you understand the theory of how to build a wall? Do you know what proportions of concrete versus brick versus, how you set up the line so that it's a straight wall? So when you take that together, you understand how the wall is made, you exemplify your understanding. And then when you actually, with the basic tools, sit down and build that wall, that's your actual application. But take that a step further. Right now, you can build a straight brick wall. What if somebody wants a curvy brick wall, or someone wants some windows in their brick wall? Are you competent because you know how to make the straight brick wall a curvy windowed brick wall? So it shows that it depends on what you are talking about being able to do, and that a basic competence may not be sufficient for a more complicated, in this case, wall, but in our case, complicated procedure. And the other thing that I think we always need to be considering is that to remain competent, we need to continue to study new methods, techniques, materials, regulations, design, etc. The way that I sort of look at this is, I think back to 2 years ago when COVID hit, and many colleagues turned to me and said, "Hey, Susan, you've been online for a long time. Can you show me how to do this?" What I trained people on, and I see people on this screen that I talked to back in those days, what I trained you all on back then is very different from what I might be talking to you about in a training today. And that is because in 2 years, we've had this extremely compressed timeline that has taken us forward in our understanding and our use of technology and the effects of that use of technology on what we do as dispute resolution professionals. So your competence is not learning how to use Zoom 2 years ago, which was very much what we were focused on. And today we have layered in a great deal more information based upon what we've learned over this, again, compressed period of time. That video that we all just watched and laughed at, I love that. 2 years ago, that wouldn't have been funny to any of us because we wouldn't have had any understanding of what was going on there. This time we're all looking at it, and I saw so many of the few people whose faces are showing, I saw so many nodding heads and the laughing comments because that's become a common part of our vernacular. So has our understanding of using all of this stayed up to date in these 2 years and in this compressed timeline? So we're going to talk about that. One thing that I do, I'll go to the next here because I want to talk about, I'm going to dive into some of the underlying understanding of competence as it applies to us as dispute resolution professionals. But I'd like to say, I love Colin's quote here. I hope you all got an opportunity to see his wonderful program yesterday. But this, I think, really sort of gives us a great example of what competence looks like when it comes to technology. He says technology is like stage lighting for a play. It shouldn't be the focus, right? If people are walking out of that play talking about the lighting, that means the play or the lighting was probably a problem, was not a success. If people are walking out of your dispute resolution process talking about your technology, that's not a good sign. That means that the focus is somewhere other than on what it should have been on, which was the dispute resolution process. Technology is the tool, it's not the star of the show. So one of the things I wanted to dive into, because we saw the funny video, we saw, even it can happen to all of us, right? Steve, he got muted somehow. We see that happening. There are going to be these technological glitches that come along. Sorry to use you as an example, Steve, but I've been trying to advance the slides, and as I click, the buttons have been getting stuck and they keep moving in ways I don't intend for them to happen. This is always going to happen when we start inputting technology into what we do. One of the things I wanted to just mention quickly, Ellen talked about it. I'm not going to dive into the cybersecurity side or the security side of competency. You had an entire panel of that yesterday, which was wonderful. And I encourage watching the video if you did not get a chance to see it. But I want to dive under these little glitches in technology, these little funny things that happen, and show you another layer, some nuance of how competence might apply. So let's take a look. Oh, sorry. See, there it goes again, getting stuck. This gentleman, I think we've all seen this participant in one of our proceedings, whether arbitration, mediation. I indelicately call this the up the nose view, where you are looking at a participant who has poor camera placement, and we are going to spend the entire proceeding looking up his chin, up his nose. What we are not getting is a good view of his face, his facial expressions, etc. We've also seen this gentleman who looks like he's in the witness protection program, right? He has bad lighting. We can't see his face. We've all dealt with him in our mediations, our arbitrations. And then we've got the always fun meeting with a bunch of black squares where everyone is having a bad hair day and doesn't want to turn their video on. So this happens all the time. And these are, again, these could be in that Zoom video. They're funny until we start to consider this with a little more nuance. So look at this young man. We have 9 pictures of this gentleman, and all we have is what we see on a Zoom screen or on a video thumbnail. if you look at each one of these, I think you have a very good idea of the emotional content that is being communicated by this young man through his facial expression, his body positioning, etc. And that makes a lot of sense because human beings communicate with eye contact. We've got that here, facial expression, gesture, posture. It's all very visible on a screen. Voice, speech, cognition, comprehension of language, intonation, those are all other ways that humans communicate, but it's not an equal balance, right? It is under Marabi's uneven triad of communication. We know that the majority of our communication is visual. It's body movements, it's face, it's our arms. It's this young man that we're looking at here. Less than half is actually the tone of our voice, what we say. So now let's go back to those somewhat funny screens that we were just looking at, those participants we've all had in our proceedings. We've got, the gentleman who we're looking at his bad angle. We've got the gentleman whose face we can't see because he's in the dark. And we have all the people who have chosen not to turn their cameras on. But now when we layer that against an understanding of the fact that people communicate visually, does that change our perception of whether this is funny or acceptable in one of our proceedings, right? And it raises questions. It raises the question, and this goes directly to what Ellen was talking about when it comes to providing equality and fair process. Are these participants able to fully participate? Does the neutral have any obligation to educate these participants? I heard in the poll, it was parties and witnesses who caused the most disruption. Well, had they been educated beforehand, and does that fall to the neutral to do that education? When does that education happen? How does that education happen? So I use this as one small example of how what we've learned in this compressed time frame has told us quite a bit about what we as professionals need to be layering in to what we are doing on the screen. It raises questions for us as proficient and competent practitioners. What do we know about communication online, the psychology of online, as it applies to our use of technology? We are the keepers of the process. So we have to remember that if human communication is affected by the impact of technology in a dispute resolution process, is it part of our knowledge, understanding, and application that we're letting people know about this, and we are capable of bringing this to the table? So that's one example of where competence dives far below having a good use of Zoom as a professional in the room, as a dispute resolution professionals. And my colleagues are going to take this a little further. Steve, I think you're muted still.
Well, I am a good illustration. I'm the poster child for some of this. But I think before we leave the duty of competence, one more thing we should note. It's really beyond the immediate scope of our program today, but I think it's worth noting. When we think about competence, we, of course, as we've been emphasizing, tend to think about having the skills to operate the technology and that we use and to avoid failures. Another aspect of tech competence for ADR professionals and participants also includes the assessment and the confidence that each of us has to have that the hardware and the software that we use is adequate and it's appropriate for the purpose, and that security and cyber protections, which, as Susan pointed out, you've heard plenty about on other programs, are adequate to the need and are up to date, especially when you receive private data. In the course book materials that we've provided, we want to refer you in particular to ABA Formal Opinion 498, which was issued by the ABA Ethics Committee. And this addresses at some length some of these issues for lawyers. So how does an ADR neutral or counsel assess one's competence in terms of hardware, software, and protection? Well, if you're in a larger enterprise, like I used to be at Sidley Austin, you have a ginormous IT department that can do that for you. If you're in a smaller enterprise, let's say, for example, Bierman ADR LLC, you have to do something else. There are tech consultants that abound, and there's really a burgeoning field of tech consultants who, not just for ADR purposes, but for business purposes, will consult with and do an audit of your tech health, so to speak, and will recommend to you what you might do. Anyway, that more than what I've just said is really beyond our scope today, but we wanted to mention it. So thank you so much, Susan. Turning to the duty of confidentiality, let me ask Paul to address this. The duties of confidentiality are a little bit different for lawyers as opposed to mediators or arbitrators, but take us through some of the ways that these collective duties come into play with the use of technology.
Thank you, Steve. And I must admit, in getting ready to make my comments, two things from what Susan just said. I did do my research starting on the World Wide Web using Google. So we have that in common, Susan. And secondly, I'm very self-conscious about my lighting. I hope I look like I'm coming out of the witness protection program, et cetera. But we can talk about that later, but please not in the chat. So I think as it relates to duty of confidentiality and the different forms of ADR, I think it's important to look at. And I think the lawyers know what our duties are. And I think the important thing, taking a step back, is the rules haven't changed. The application in many respects changes because of the technology. And I think that's something that in going through all this, and then frankly, spending some time reflecting on the last 2 years, which have felt like 20 years in a lot of respects, because today is March 4th. I don't know about you all, but my world kind of changed. I believe it was March 12th or 13th of 2020. So it's 101 weeks, I guess. Feels like 1,001 weeks in a lot of ways. When we look at it, everyone knows the rules and they've been reminded of them. But when one of the things I did to prepare some remarks for today was to talk to some of my go-to mediators who also arbitrate and kind of get their info. And someone was kind enough to collect information for me on a non-scientific but highly anonymous basis. So these are some of the things, and then I wanted to compare it to the literature, and amazingly, it was like a perfect fit. So here I'm going to go grab bag, good old-fashioned trial lawyer style. My comments are written on yellow legal paper, very fancy. Everyone tells everyone to disengage your record features when you're on a Zoom. That's really important. It's really important for people to actually know. Most people I've noticed don't even know when something's being recorded oftentimes. So you have to know that. And there's a huge element to what Susan just said about education. I think the neutral has to be in a position and should be in a position to be teacher. It's their proceeding. They are operating as the judge, whether it's in an arbitration, but really somewhat of definitely an authoritarian role as a facilitator in a mediation to set the ground rules and make sure everyone is comfortable. Oftentimes, lawyers, I can certainly speak for practitioners in this regard, don't like to say when they don't know what they're doing with technology. So if the neutral can lead into it and maybe even have a survey or something like that, I've seen that work really well. A pre-call to deal with technology. There has to be a meeting number and a password to enter the Zoom. All parties have to come through a waiting room, similar to how we entered today. Only admit people who are disclosed and recognized, which is also important. I have heard many people comment whether it is judges as well in whether they're acting as overseeing settlement conferences of federal magistrates or otherwise. A real pet peeve is having your son or daughter's name on your screen instead of your own name. And also many courts I found, and neutrals as well, want not just your name, but the party you represent or your firm listed. Those are little things, but it makes everything smooth. And it also is a way to kind of show that you know what you're doing and you're nimble on it. So I think those are the examples of little things that we can do. Instructions about no recording or no broadcasting during a mediation or an arbitration, having a secure internet connection, which Steve just mentioned, requiring parties to sign agreements for mediation using the strictest mediation rules. I'm in Texas. I think Texas has perhaps the strictest mediation rules. Other states, they vary from state to state. Requiring confidentiality and privacy and understanding the difference between confidentiality and privacy, because I think those two things often are used interchangeably. Reiterate at the beginning of every session or every day, whether how applicable, who's online, who's on the screen, and who's not. Get everyone into the habit of that, just like you would do in a courtroom or in a conference room if it's an arbitration. Who's here today? Many of the neutrals I spoke with talked about shredding hard copies of materials or deleting the soft copies, electronic copies of materials as soon as they can when the agreement is final, and letting everyone know that. I get notes from mediators saying, I'm going to, unless anyone has an objection, I understand the settlement's finalized, been approved, I'm going to delete my materials in 7 days or whatever. So things like that. But there are issues, and we could do a whole several hours on this as to whether a mediator's assurance of confidentiality is truly enforceable. There have been cases where it might be provided under one state's law and another state or a federal court in a different jurisdiction decides to handle that differently. That is a real issue that I think it deserves attention to make sure that a mediator or a neutral is not put in a position of over-representing the confidentiality of the proceeding. Not to be provocative, but I just think that is something to think about. There are audio and visual considerations regarding confidentiality. If you're at home, close your door. I heard when Ellen was speaking, it sounds like the law enforcement was after someone. We can't control that. And we really can't control the lawnmower and all those different things, but you can control or mitigate the vacuum cleaner, or when we were truly work from home. Anyone knew in my house, my 7-year-old piano time was 4 o'clock Monday, Wednesday, Friday. And they'd hear it through my door. Having a 360-degree view in terms of, sometimes people want to know what's around you. If you're in a testimony situation or you're in a confidential meeting situation in a mediation, keeping video feed on. That's important for different things in the sense that you're trying to simulate an in-person proceeding. First of all, many people find it to be rude to turn off a camera when you're actually in a proceeding. That's kind of like if you're in an arbitration or mediation, turning off your camera without permission is kind of like walking out of the room, which can, we all know the dynamics in mediations when one party leaves early or has a flight to catch, etc. Those sorts of things. Agreements not to take screenshots. When people share a screen, not to take a screenshot, but also sharing a screen instead of emailing documents. And I think the other notion is, in these remote proceedings, it is harder to maintain client confidence when you are working in a non-traditional setting than when you're in your office or in a conference room, etc. So I think those are things that are worth keeping in mind. I want to share a couple of anecdotes. I was in a hearing, but it would have been the same thing as if it were an arbitration last summer of 21. And the lawyers were in one conference room and our witness was in a different location. Judge was in the courtroom. Everyone else was remote. I had a an senior associate who was doing a direct examination. We were online by audio and on video without sound on our computers. And we had one speakerphone for the whole conference room. During the questioning of the witness by my colleague, I was doing what was done to me when I was in her shoes, and I was telling her, hey, how about this, or how about this, or how about this? But I was really not in sync on hitting the mute button. So what happened? My opposing counsel, and it was a contested matter, complained that there was coaching of the witness going on through my commentary or my nudges to my colleague, none of which, of course, she needed. And the judge, and I was fortunate, the judge jumped in and said, hey, Mr. Janender, let's be a little better on the mute button. I know, and he was also very gracious, and he said, let the record reflect, I know you weren't speaking to the witness, I know you were speaking to your colleague, but just be careful so it doesn't look that way. All that said, real cautionary tale, and I also would like to think the judge was appreciative of the fact that someone else was doing the questioning instead of me. But I also think that's not everyone's going to react that way. In the lesson, the takeaway is things can get misinterpreted. Even when you're really coming from a good place of training, it can be misinterpreted as coaching. I want to share one other experience I saw, and then an anecdote perhaps to close on. I hope I'm doing okay.
Hey, Paul. We are running close on time, and for everyone's benefit, we're gonna go a little bit, not much, but a little bit past 12:30. But Paul, if you could kind of sum up whatever your anecdote is, be great.
I will. I'm gonna go. I want to talk along the lines of what I just said. If you're familiar with the case that was dealt with in federal court in Massachusetts, there was an order to show cause and a lawyer who was sanctioned, where he was found to have committed misconduct when he, quote, exploited the remote nature of the deposition to improperly assist a client. He was feeding responses behind a mask, audibly whispering. When he was confronted during the deposition, he denied it and moved on. What did they do? They actually checked the recording and found more than 50 instances where the opposing counsel could hear the offending lawyer, quote, surreptitiously provide the answer to the client who repeated that answer. The lawyer later, after admitting he did it, pretty hard to refute it, right, when you get caught, said he was doing it because of frustration with opposing counsel's questions. So I would think if you were frustrated with your opposing counsel's questions, the remedy is to stop the deposition and call the court or something of that nature, but not improperly coach a witness. Terrible behavior allowed because of the technological world in which we live in, which is unfortunate. So at the end of the day, I think just in closing, when you want to know and see and be comfortable with your environment, many of the things I've talked about are akin to what we would do if we were going to try a traditional lawsuit. Maybe the week before, 2 weeks before, you go to the courtroom, you inspect, you see where you're going to stand, you see where all your equipment's going to go. I think a lot of those things now have to happen on the fly. And I think we have to be far more vigilant, because I think technology, regrettably, allows some people to succumb to their weaker or worst impulses instead of truly remembering that the ethical rules apply, whether we're across a table or on a video stream. So thank you so much.
Well, thank you, Paul. That was terrific. For everyone's benefit, if you're keeping track, CLE code number 10 is mediation. 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 Let me turn to Jill, and I'll say again to our audience, we're going to run just a little bit past 12:30. We started a few minutes late, and we're running slightly long, but we'll go a few minutes past 12:30. Jill, the duty of maintaining a fair and quality process is central to what ADR neutrals do, and is equally important to practitioners before those neutrals. Can you take us through some of the highlights of the issues there?
Absolutely. And with respect to Ellen's buckets, you can't have a fair and quality process if you don't have competence and confidentiality covered as well. So you want to make sure of that. And I want to start by saying that as a neutral, as all of you do, I'm sure, I take my obligation and responsibility to run a fair and quality process very seriously. I'm usually either the only arbitrator or the chair of the panel, or if you're a mediator, you're usually by yourself. You need to have the attitude of respecting yourself as a professional, respecting the parties, and respecting the hard work of the counsel to prepare and represent their clients in that context. So you have to bring that all together with your professionalism and look at it from that perspective. You are required to have a fair process for everyone participating. And as has been discussed, when you have pro se parties, which I have often had, you have to go that extra mile, but navigate that line between assisting and ensuring a fair process. So that's very important. Obviously, having a clear internet connection. There's certain, so one of the ways that I ensure a fair process is in the preparation. Those initial pre-hearing conferences to set up the proceedings are very, very important places to set expectations, to remind counsel and parties what needs to be taken care of to ensure that the process is fair, confidential, and that there's a quality procedure for everyone involved. So I remind the counsel, make sure that your witnesses and the parties have adequate technology for the day of the mediation or for the day of the arbitration. I had one key party and witness in an arbitration, an online arbitration, come and testify on his iPhone. And I was very concerned. We had discussed having all the technology ready, but he put his iPhone, propped it up on something in front of him. There was good lighting. We were able to see enough of his body and his face and his gestures, and it worked. I was a little skeptical, but it did work. So the basics you go over with counsel, your fellow arbitrators, if you're on a panel, and you help the counsel have their checklists checked, because it's very easy for counsel when they're representing parties and they're in the fight to forget some of these things. So as a neutral, it's very important for you to do that. One of my important rules at the beginning of an arbitration or a mediation, I indicate to everybody that comfort breaks are always permissible. And if anyone needs one, just raise your hand or speak up so that we will do a comfort break. Comfort breaks are important for Zoom fatigue, right? They're important because if someone starts being squeamish, and it could impact your assessment of their credibility. I was once in a hearing. It was a major sports hearing, and there was a large panel of 7 arbitrators. One of the gentlemen on the panel was of a certain age, and it was very difficult for him not to have frequent comfort breaks. So at some point he couldn't take it anymore, and he got up and started walking out of this huge room with, I don't know, there must have been 30 people in the room, and the whole panel kind of turned and looked as he was walking towards the door, and the chair got the signal, okay, I wasn't sharing that he had to stop the hearing because this gentleman had to leave. You don't want to put somebody in that scenario, right? Zoom fatigue and just normal comfort issues are very important, whether people need to get a coffee break. Those are things that I remind folks to ask for if we don't have a natural break, but I frequently mention it. There's a whole issue of the digital divide. The digital divide can be socioeconomic. It can be gender related. I love that in that very amusing video, the boy interrupting his dad, not his mother. I like that. And it can be gender and tech savvy issues in terms of the digital divide. You can be talking to a person of a certain age about certain technology things. And if the person talking to them is 20 or 25 years old, their understanding of what the issue is going to be different than, say, my baby boom generation could be different. We have an obligation as part of our competence and fairness of process to make sure that regardless of the age of the parties who are testifying witnesses or our panel or the gender, that we are sure that the competence level is going to be attended to, the technological competence level. Some people like to participate in proceedings on iPads and tablets rather than PCs or laptops if they have it. If you are in a household during COVID or a flu outbreak in your house and everybody is home or it's a holiday for the kids and all your devices are being used, so hopefully you didn't draw the short straw and you get the worst working tablet or God forbid, just an iPhone to work with. But all those things have to be talked through and dealt with. I won't start the proceedings until we make sure everybody is clear, visible, that everyone is set to go, that it's an even playing field for everyone participating. That's very, very important. You want to make sure that everybody's voice is heard and that they understand that their voice is being heard and attention is being paid to them. And so beyond that, one of the things I do in the setup is make sure that in my setup, if I'm setting it up for Zoom, that you tick the box that everybody comes in on mute, so that there is not a situation where they're saying something and that gets overheard inadvertently. And you don't want to capture conversations that you're not intended to have. So competence is key, it's very important. You want to understand that your performance, your competence and your ability to deliver a fair quality process is key to the parties and their counsel's feeling about whether they got justice, and it's their window into the dispute resolution system. And if this is the first time they've used dispute resolution, you want them to have a good experience and know that this is a very viable alternative to costly or perhaps more costly and certainly more time-consuming litigation. So I'll leave it there so that we might have some Q&A.
Well, thanks so much, Jill. And without a fair and quality process, we really have nothing. So your points are indispensable. Let me ask Susan to very briefly comment on hybrid proceedings, meaning not mixed mode, but rather proceedings that combine elements of being in person and elements of being remote as kind of the new normal, or even newer normal. Go ahead, Susan.
Absolutely. So the word on the street is that hybrid meetings are becoming the norm. And I think we can certainly expect that there will be a rise in hybrid proceedings for us as dispute resolution professionals. The one thing I really think is important for us all to understand is just because you know how to use Zoom for a fully online process, it does not mean that you are, sorry, this is jamming again, that you are fully competent to do a hybrid proceeding where some of your people are separate from you and some are present in person. There's technology issues that you're going to face. You have different video cameras that you're going to need. You need to make sure that you have audio and microphone and speakers so that everyone can be heard within the room, even if they're just, remote. You're going to need to have a display where all of your remote participants can be seen, as well as screen shares. And where all that's going to be placed in your conference room is something you need to be considering ahead of time, not when you start a hybrid proceeding and then realize you don't have these things. You also have some psychological issues. There's a very different feeling for the people who are in person with you versus people who are separate and remote from you. There's team mentality issues, us versus them, in person versus remote. That is an internal perception. The perception of your neutrality may be challenged because you're with some people and others are remote. And remote participants can feel marginalized. So you need to have some strategies for how you're going to deal with those things ahead of time. You need to be aware of these issues. You need to use some inclusion strategies, and we don't have time today to go through those, but use your ever-present Google function, as Paul and I did. Educate your participants. We have mentioned that throughout this process. There is no substitute. You need to be educated. Part of your responsibility is educating your participants. You need to be transparent about these issues so that people can make educated decisions about being hybrid, and you may need to modify your process and think about that ahead of time.
Well, great. Thank you. That was terrific. Let me ask each of our panelists very briefly, each of you to give us one key takeaway as to how neutrals and counsel can avoid the kind of traps we've been talking about and meet their ethical obligations. Susan, again, we'll start with you.
Sure. And I'm going to start with education. And that will go to your continuing education. It is an ongoing duty to remain competent. We've been through that, but also to educate your participants. Your education has to extend to the people who are participating in your proceedings so that they can participate fully.
Thank you. Jill, a quick takeaway.
Prior proper preparation. You have to take your preparation for your proceedings, whether they're arbitration or mediation, very seriously. You're sort of the maestro, the conductor of the proceedings, at least as a neutral. Obviously, counsel have a different perspective, but whether you're counsel for a party, you need to be prepared to, of course, represent your client to the best of your abilities and understand and take instruction from the neutrals who are in charge of the proceeding to make sure that you are giving effective representation to your clients. My tips are set up your breakout rooms early and have a separate breakout room just in case there's a meeting that you need to have that you didn't anticipate. Make sure in an online video setting that the exhibits, if you're going to be doing electronic visit exhibits and binder exhibits, you're going to have to double check to make sure that the pagination is the same on each, because in a binder, you might have sheets of paper that you don't have in the electronic exhibit. And I would also say, expect the unexpected, technology glitches, people will be people and act as people do. So something may and will possibly go wrong. It's very important as a neutral or even as counsel to be calm and project professionalism and control, because that will help the parties and the consumers of the process to understand that, okay, even though something went wrong, it's all going to be okay and everything is still on track. Those would be some of my takeaways.
Thanks, Jill. And Paul, a quick takeaway.
Well, on practice, I think practice is a key. I'll modify. Jill said to be calm. I'm going to say that I would want to appear calm. I think there's a big difference. Practice is important. Getting your client comfortable either testifying online or speaking to a mediator online is really important. Do a dry run. What is your case about? The mediator is likely to ask you X. The mediator is likely to want to know Y. and go through it, not to rehearse it, but to get so that the technology is an enhancement to the authenticity, not an impediment. And as it relates to the documents in any setting, have them ready to go to the specific page, highlighted, and have someone, it's definitely not me, ready to have them blown up so they can be read easily on the screen, so that you can't control all glitches, but you can prevent against several. So thanks.
Thank you, Paul. And Ellen, take us home.
My very brief comment, and I understand that we can continue the conversation over lunch, is stay tuned. We've talked about the pre-existing ethics rules. There are new rules coming down the pike all the time relating specifically to remote proceedings. So the ethics guidance we have now is not going to be a closed universe. It's ever expanding.
Well, thank you, Ellen. And thank you all. What a wonderful panel. What wonderful insights. All of us want to conclude by recalling the famous words attributed to a 5th century BCE Greek philosopher, 2,500 years before Zoom, before Teams, before WebEx and all the rest, before AI, before my avatar, but still as true today. The only constant in life is change. Thank you all very much.
Thank you.
Thank you.